end list. It's not as funny as Letterman, but it gets to the points I want to get to. One of the first things I want to say, and it's echoing what Johnny just said, there are multiple considerations. Primarily, I represent law enforcement. However, I also represent public officials at times as well. And there are more than just economic considerations in terms of how those claims are handled. You have to remember, and I've had police officers in my office in tears about an event for which they did absolutely nothing wrong. Nothing wrong. They take their job very seriously. They're very professional. And remember, police officers do not go into the profession to hurt people. They actually go into the profession to help people. So when there's an adverse outcome or something goes awry, or whatever the case may be, and they have to use lethal force, or there's some event that triggers a serious injury to somebody, it affects them very, very, very seriously. The second thing is you have to remember, as I'm sure most of you are aware, as public officials or related to the community, these cases are important to the community. They send a message to the community. The community wants to know that basically our officials are doing right, our police officers are doing right. It affects the entire sort of circumstance of the community. And remember, a lot of rural communities, it's a big deal. And it's a big deal if one of their officers is accused of doing something, alleged to have committed excessive force or done something untoward. It's important that that officer be vindicated. It's not a monetary thing. It's to get the officer vindicated. I had a case a number of years ago. We tried for 3 weeks in federal court. And in my closing summation, one of the things I said to the jury, it was a shooting case, officer involved shooting, gentleman killed. Basically, they followed him, went to his house. This was in Utah County. And he turns around. There are 2 officers involved. He turns around. He goes like this. It's dark. It's about 9 o'clock, 10 o'clock at night. He goes like this. And all they see is some metal in his hands. And they think he has a gun. What he had was a box cutter. And he might have been trying to commit suicide. Nobody really knows. He might have been trying to slash his wrist. But anyway, all the officers saw was this shooting position, classic shooting position, and they see the metal. No question the box cutter was there because it was found after he was shot. The officer responded. One of the officers, my guy, kills him. Now, we went through a lot of discoveries, a big case, a lot of investigation, serious injuries. The family was saying basically the police shot him in the back when he was on the ground. There were all kinds of experts, forensics, the whole 9 yards. And of course, you get to the point, at some point before trial, where maybe the plaintiffs will say, well, we'll settle for X. And it might cost you X plus to go to trial, especially 3 weeks in federal court. That's an expensive proposition. But the whole point is we didn't do anything wrong. Our police officers did not do anything wrong. And so we were going to try that case to a verdict, and we were going to vindicate those officers. And remember, these are people who killed somebody, and they are feeling the impact of that emotionally. They're feeling the impact of that for the rest of their law enforcement career. And remember, the community is sort of aware of the event. And so it's sort of a vindication not only of the officers, but a vindication of local officials. And remember, police officers in many respects are considered leaders in the community. So it's very, very important that we try the case. Try the case. Closing argument, one of the things I said was, held up the verdict form, special verdict form, where you can check no cause of action. Essentially, I said, this is what you have to do. Check that box. No cause of action. You vindicate these officers. I said it about 3 times. I guess it got through because the jury was out a couple hours and basically found no cause against the plaintiff. Very, very important, because if you went back a month and a half before the trial, there was some money that was offered by the plaintiff's lawyer, and as I said, that was X. It cost us X plus to try the case. But the outcome was very important to those officers, and very important to the community, and very important to the officials involved who had to deal with what was a very serious event. Obviously, an officer involved shooting when you kill somebody is a serious event. So the first thing, number 10, police officers and other public officials need and deserve to be vindicated. I don't know how many cases I have where, as I say, the officer does absolutely nothing wrong, nothing, gets sued. And I don't know, I'm sure some of you in this room have been sued. It's not fun, because somebody's making an allegation directly at you personally and saying, you screwed up. And plaintiffs have a wonderful way, when they put these complaints out, of saying all manner of ugly things about people, and about officers, and about public officials. And lots of times it's not even remotely correct. But there it is, public document in court about you. Trust me, it's very personal when you're sued. So the vindication is very important. Not only is it needed, but it's deserved. Number 9. And by the way, I'm just trying to give an overview of all the reasons why you should be aggressive when you defend these cases. Quite frankly, I don't know any other way to do it myself. But that's what needs to be done, because a lot of good things come out of that. And that's what we're going to go over. Okay, plaintiffs' lawyers have a financial incentive to settle. My view is, make them work. Remember, what a plaintiff lawyer wants to do, ideally, file a lawsuit, hold out his hand and say, okay, pay up. Where's my money? I got a great claim here, where's my money? That's what they want to have happen. And quite frankly, in this day and age, there are still lawyers that think that way. They think we're going to sue a governmental entity, we're going to sue a governmental official, we're going to sue a governmental whatever. There's some kind of liability coverage behind that. And basically, just by filing a lawsuit, we're going to settle the case, and we're going to make a buck. That's what they think. So my view is, okay, but you're going to work really hard to try to get any place in this lawsuit, because the more you work, the less attractive that case is going to look to you, because you're thinking, wait a minute, I'm putting in a lot of effort, I'm putting in a lot of time, I'm putting in a lot of resources, I'm starting to have to dig into my pocket to pay for depositions, for experts and other things, it's coming out of my pocket. It becomes a financially very, very challenging situation many times for the plaintiffs. Let me give you an example. We got sued, about a year and a half ago, 2 years ago, in federal court. The allegation was that some police officers showed up at an apartment, and this fella had his car booted because he was parked in a space he shouldn't have been in. So the landlord's agent went out and booted the car. He was furious. How dare you boot my car? How dare you? Okay. Police show up, and he starts to get out of line. Well, it ends up in an altercation, because he basically starts going after one of these police officers, and one of the police officers is trying to defend himself, and ultimately they wrestle him to the ground, put cuffs on him, and then they haul him off to jail. And he's saying, excessive force, you started it, you hit me, da-da-da-da. That's the allegation by the plaintiff. Okay, fine. He's represented by a lawyer who's, a fairly decent lawyer. Okay, so we get the case. We immediately sense there's a little video of it. It doesn't show the whole event, but there's a little video of it that you kind of see what happened. You can hear what people are saying. So it looks like this guy went off, kind of a nut, kind of crazy, and started the whole problem. And the police are just trying to please, will you leave me alone? They're just trying to deal with the situation. That's the way we saw it. So anyway, we start doing discovery. And we start finding out that maybe what we are thinking is absolutely correct. Then we take this guy's deposition. Pretty interesting deposition. He was the kind of guy where we said, okay, what do you do? And he goes, well, why do you need to know that? Where do you live? Well, why do you need to know that? I mean, it was just odd. I mean, the first hour was more like, would you please just answer the question? Well, why do you want to know? One of those kind of guys. But very, very difficult, and obviously having a little reality problem. No question about it. So we do the deposition, And then after the deposition, there's some things that come out, so we want some more information. It's relevant to defending the claim. But the whole view is, we're thinking, you know what? This guy is a problem. This lawyer knows he's a problem. This lawyer doesn't particularly like his client. This guy can't possibly be communicating very well with his client, so we're going to keep the pressure on. Next set of interrogatories goes out. Next set of requests for production goes out after the deposition. Guess what? Lawyer says, would you stipulate to us withdrawing from this case? That was the next phone call. Okay, fine. He had enough of his own client, and quite frankly, had enough of his own client too. But anyway, so eventually he got out of the case. So now this guy is in federal court in a major civil rights case based on these facts, and he is unrepresented. So how do you think that works? Doesn't work very well. And obviously, we knew there's no lawyer in the world that's going to touch this case. They don't want to have anything to do with this guy. So anyway, so after we go through a few weeks of machinations, and the court enters an order and says, basically, you need to do this by such and such a date. If you don't, I'll dismiss the case. And of course, what does he do? Nothing. Boom, the case gets dismissed. But the reason why that worked is because we were aggressive and assertive about the case. We knew there was a problem, and we knew that the plaintiff didn't want to have a piece of it. He was losing money. It was never going to work, and all of a sudden we're making it work. My view is make it work. Work, 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 work. If you think about it, just in your own common experience, this is my view. Could be wrong, but I don't think so. Most people don't really like to work. It's, working hard is kind of hard stuff. And so we're going to make these plaintiffs work. They're going to get anything, they're going to work for it. Next, 8. Okay, this is a classic. This is consistent with what I was saying about being aggressive in discovery. We had a case, another one a few years back, and it was a very serious case because the plaintiff was tased. The plaintiff hit her head on some concrete as she went down. I'm not minimizing the issue here about her injury. And she did suffer real brain injury. She was a week and a half at the University of Utah Medical Center. She had a real hematoma on the brain. She had bleeding. That was all, no question about it. And it was all because the tasing, when she fell, she just hit her head, and that caused the problem. Young woman, married, no kids. So anyway, so they filed this, once again, Major League Civil Rights case, claiming that these were brain injuries, brain damage, residuals are terrible, she can't work, she can't do this, she can't do that, they want millions of dollars. Okay, so that's the fact pattern. So we not only go through discovery, but we of course file the defense that is the common defense that some of you I'm sure are aware of, qualified immunity. Where basically you say, look, the officer didn't violate anybody's constitutional rights, but even if they did, the law was not sufficiently established so the officer would have known that he was violating constitutional rights, so therefore he's entitled to qualified immunity. That is the defense that you always use in civil rights litigation. And the court rejected that. So then we took it up on appeal to the 10th Circuit as we can. I'll talk a little bit about that. And they upheld the trial court. So we're back. We have to deal with this case. However, we offer some reasonably, and I'm not saying it was something that was great, but it was a fairly tidy sum under the circumstances because the concern was brain injury, tasing, may not be that helpful with the jury. I'm not so sure I thought that. This was not, by the way, used as a case, but it was a governmental case anyway. So it has nothing to do with John Deere Corp or anything like that. But anyway, so they want millions. No, we want millions. Okay, we go to try the case. Now, The one thing they didn't know or didn't understand or didn't appreciate is we had been quite thorough in our investigation, quite thorough in our discovery. And one of the things that we came up with, as I'm sure all of you now can appreciate, Facebook. She had a Facebook page. And guess what? We were able to log into it because somebody ratted her out. And so all of a sudden, what we have is, and some of these are recent posts, photographs, and what we have is a glam shot of this young woman 2 months before the trial. I'm telling you, she was a very pretty young person. She looked wonderful, wonderful. So here's what plaintiff does. Plaintiff has, we tried this a week and a half. Every single day of the trial, she shows up, and it's like, who is this woman? No makeup, looked horrible, looked like she'd been, hadn't slept for weeks, and she was dressed in some very plainish clothes. I mean, to paint the picture that this woman is now brain damaged, and look at her, just look at her. You just want to give her money, you just want to. That's what they did, seriously. Well, this jury's not stupid, and we're not stupid either. Because guess what surfaced in the middle of this trial, and they couldn't do anything about it? The glam shot. And in closing argument, we had a nice little photo display. Wasn't too music, but it might as well have been. And anyway, and there we have her skiing, we have her doing this, we have her do that, and it ended up, and this is how I concluded it. I said, ladies and gentlemen, and then we have this. And there was this beautiful young woman with this wonderful glam shot that had just been taken 2 months before. And I said, you have not seen that woman in the courtroom, have you? That's all I had to say. Because she was right there. They saw her, and they go, wait a minute, this doesn't line up at all. So anyway, 2 hours, they no cause complaint on that very serious situation with Daisy. But that's what you do when you go and really want to get to the facts. You've got to get to the facts. You've got to be thorough. You've got to be aggressive. You've got to be assertive. You've got to get to know everything. Because there's always something. Trust me. There's always something. I don't know how many cases I've had. Zillions. Matter of fact, every single one. And here's what happens. I read the documents the first time. Okay, fine. Whatever. Who cares? I don't know. Anyway, then I read them like this the third time. As we get closer and closer and closer to like a significant motion or trial, or whatever, you start reading these things. Holy mackerel, look at what's in here. This is great. There's always something there. But you got to keep digging. You got to keep looking. So that's the benefits of being aggressive in discovery. Also, remember, it also affects plaintiffs adversely financially, because once again, you're making work. They have to pay. They don't get paid for this. They're all on a contingent fee, or they're expected to get the 1983 attorney's fees award. So the more time they have to involve, it's like they get less happy about things because they don't want to work, because they're going to make money if they don't work. They don't make money if they're doing all this kind of work. All right, number 7, right? By the way, I know it's not as funny as Letterman, but anyway, okay, U.S. Supreme Court. Let's stop there. I have done a study, which is pretty scary because I did it. Anyway, from 1998 until just May of this year, there have been about 15 cases out of the United States Supreme Court that addressed law enforcement issues. Typically, the claims of Fourth Amendment claims dealing with excessive force, typically those kinds of cases. Supreme Court, with the exception of one, has ruled in favor of law enforcement. And they have generally reversed the circuits. They have a totally different view of the situation than circuit courts do. The law is very favorable to us. Let me give you an example. The one in May, it's called the Rickard case. And it's very interesting because what you have is a fellow who stops and then he takes off. And of course the chase is on, the pursuit is on. So they go through the streets and what have you, and at some point they reach speeds of 100 miles an hour. There are 2 officers following this guy, and he's not stopped. Finally, they kind of get him cornered, so he stops. There's like 5 officers around. And he starts going moving his car forward, hitting the cop car in front of him, then it goes back. You know, he just doesn't stop. So these officers don't know what to do. He's not obviously stopping. He has a passenger in the car. So at some point, they shoot at the car 3 times to try to get this guy to stop, because he's endangering these officers. He's going to run somebody over. He's a crazy person. He eventually escapes and takes off. And they fire 12 more rounds at the car. You know, maybe 3 or 4 officers. 12 more rounds at the car. They're not sure what killed the driver. They're not sure what killed the passenger, but we know they're both dead. Because the guy runs into a building and crashes the car, big mess, and not only is the driver killed, but the passenger's killed. Pretty egregious set of facts. Now, Supreme Court gets it after the circuit courts have all said, this is not consistent with the Constitution. You cannot do this. This was excessive force. Da, 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 da. Supreme Court says, wait a minute, you've got to be kidding me. There's no constitutional violation there, because they say, and I'll just read the language because it's kind of significant to show you kind of where the Supreme Court is. It's very short. Supreme Court says, Rickard's flight posed a grave public safety risk. And here, as in Scott was another police chase where they knocked the guy off the road, he hit a tree, and he became a paraplegic. And the Supreme Court said no problem with that. The police acted reasonably in using deadly force to end that risk. They went on to say, it stands to reason that if police officers are justified in firing at a suspect in order to end a severe threat to public safety, the officers need not stop shooting until the threat has ended. As petitioner stated below, if lethal force is justified, officers are taught to keep shooting until the threat is over. This is a good case for us. And there are a lot of cases like this from the United States Supreme Court. So my point is, when you get a case, obviously, against police, you have some pretty good law, pretty good jurisprudence on your side. The Supreme Court is very, very favorable. And it goes back to 1998. It's not necessarily this particular group of justices. It goes back to 1998. And that was that was when they decided that no longer in 1983 cases, federally, could you ever take a case based upon a police pursuit. You can take a state for negligence claims, for state law, but they basically said, nah, sorry, under federal law, you basically got to show that the police officer was acting outside the scope of his employment, on a lark of his own, and almost intentionally wanted to cause the problem. That's a standard nobody's going to be able to meet, so they got rid of all federal claims with respect to pursuits. They were due process claims. So anyway, remember that. I remember it because I use it all the time. And one of the big tensions, this is where I'm going with my little study, one of the big tensions we have, which ties into Pearson versus Callahan very soon, is the United States Supreme Court is like here with the jurisprudence. The 10th Circuit and all the other circuit courts are over here. There's a complete disconnect. Pearson versus Callahan is a good example. And it's important, it's time that I say it here. But it's also a good example of you keep going. Because good things happen, you keep going. Here's what happened. Mr. Callahan was in his little house down in Fillmore, and they had a drug task force, Central Utah Drug Task Force, and he was peddling methamphetamine. And so they had an informant go into his house to buy methamphetamine, and there was a prearranged signal when he said something about drums. The police all came in. Once the transaction had occurred, bought the methamphetamine, gave him the money, and they arrested Mr. Callahan for possession with intent to distribute. Those are the facts. They did not have a warrant. They just had the prearranged signal with the confidential informant, and they went into his house and arrested him. Now, obviously, they got the methamphetamine, they got the money, da-da-da. And they also had this on some recording, so they heard what was going on inside the house. All right, so he gets prosecuted down in Millard County. And he basically says, wait a minute, no warrant, sorry, suppress the evidence, you can't get me, sorry, you never warrant, Fourth Amendment problem, da-da-da-da-da. So he says, look, I'll enter a plea, this is Callahan, I'll enter a plea, but it's conditional on this decision on the Fourth Amendment. If I win, then I withdraw my plea, and that's the end of the case. Well, the trial court said, nah, sorry, not a violation of the Fourth Amendment. But our Court of Appeals, hearing this, said, sorry, you can't go into a home without a warrant. So they dismissed the case, but basically they determined it was a violation of the Fourth Amendment, which meant that the drugs wouldn't get into evidence, which meant basically the case was over. So he goes, hey, that's pretty good. I got a written opinion from our Court of Appeals in Utah that says my constitutional rights are violated. So I'm going to go and sue you guys. And I'm going to go in federal court, and I'm going to take this opinion, and I win. That's basically what was going on. Well, not so fast. Because obviously that's a civil case now under 1983. There's qualified immunity defenses and other kind of things. So basically the trial court says, no, I'm sorry. And we came up, by the way, with a little doctrine that's fairly obscure but very real called consent once removed, which has been adopted by 2 circuits, which basically said when police are in the middle of establishing probable cause for a drug transaction in a home, and there's other police outside waiting for officer safety, if the transaction occurs, a probable cause, they can come in without a warrant. So we argued that, we argued a few other things. Trial court said, sorry, forget it, Mr. Callahan. The law is not sufficiently established. 10 circuits never ruled on consent once removed. Supreme Court has never ruled on it, so therefore you do not win. You are dismissed. That's the end of your case. So we go up to 10 circuits because they appeal it. And I'm thinking, there's no way we could lose. Because we're either going to have the court say the law is not sufficiently established, we would win then, or the court may say, well, we're going to adopt consent once removed, and we're going to insulate these officers from any Fourth Amendment problems. Either way, we win. I think, no problem. Yeah, well, it was a problem. Because all of a sudden, the decision comes back, and it's 2-1 against us. And it's completely, in my view, not well reasoned at all under the relevant jurisprudence. But it's a good example of, there's the 10th Circuit, 2-1, saying, sorry, this was a violation of the Fourth Amendment. What just happened? Can't do this. All right. So, just like Johnny was saying, boom, we do a petition for cert. And it's granted. And the Supreme Court says, we're going to take this case. We weren't sure what they were going to take it for. They might have been consent once removed. There also was another sort of esoteric thing on qualified immunity, which I won't bore you about. But in any event, they take the case. Wonderful. And then at that point, after the petition is granted, which means you're going to the Supreme Court, all of a sudden they start offering, that as plaintiffs, start saying, well, we'll settle this case for X. Thinking it's going to cost us some money to take to the Supreme Court. And, you know, and they're fairly low now in terms of what they're offering to settle for. So this becomes kind of an interesting issue. We have a petition to the Supreme Court. We now have a decision on the 10th Circuit, which is against us. You don't really know what the Supreme Court's going to do. And now there's a little settlement money on the table, which may be cheaper in some respects than actually taking the case to the Supreme Court. But true to form, bless you, Corby and Yusuf, basically I talked to the officers and they said, sorry, we do not want to give this person a dime. And the reason why they didn't is because from their perspective, which I respect tremendously, he was a drug dealer and he was a problem in their community, and they did not want to give a drug dealer a dime. So I said, well, okay, all right, fine, we get it. So anyway, so we take it to the Supreme Court, reject the settlement, and I basically told them, I said, look, I don't care. We're going to win this thing. Because, you know, if we didn't, we would have had some attorney's fees, nothing else. So it could have been consequential. But anyway, we argued. Supreme Court 9-zip reverses the 10th Circuit. And basically writes an opinion almost to say, gee, 10th Circuit, how could you possibly come up with this decision? This makes no sense given the existing jurisprudence. I mean, it was not a problem for the Supreme Court. It was almost like, you got to be kidding me. Well, that's the sort of the conflict. That's a good example of the conflict between a circuit court and the Supreme Court. Because how could you get a 9-zip reversal on something that's 2-1 circuit? And we actually petitioned for en banc with the circuit, and they always say, nah, forget it. You're not going to get a shot at the whole panel. So anyway, so that was Pearson versus Callahan. But also is another good example of you keep going, because if you really have a defensible case, and we thought we did in this instance, we thought we should have won at the circuit court level, it's going to come out okay. Okay, 6. Okay, this is important because this is another hurdle that plaintiffs' lawyers have to get over, and it kind of tends to work in our favor, and sometimes you get some decent law out of it. Some of you may be aware of this. In 1983 litigation, if you assert qualified immunity on behalf of your officers at the trial court level, and the trial court says, nope, I don't think so. Can't do it in this case. And if you have pure questions of law that exist at that point, you don't have to then proceed to go to trial. You can then appeal it in an interlocutory basis to the 10th Circuit. That's true, throughout the country. You can appeal these things to the 10th Circuit. What does that mean? Well, I'll tell you one of the things it means is it's another year or more before it ever gets back to the trial court. And then once it gets back to the trial court, you may win, but if you lose, it's still another year. And then you have the delay attendant to trying to posture the case for a trial then. So you can see it kind of makes the claim stale. It also tends to give instructions of law to the trial court that may be helpful to you. And quite frankly, sometimes they just get it wrong. I had a case where there was a DUI stop out of Utah County, and for some reason, the judge thought that even though the stop was totally appropriate, the car had been driving erratically, was in the slow lane of traffic on I-15, had not signaled correctly, so there was legitimate reason to stop the car. No question about it. There's reasonable suspicion. And then the officer talks to the woman and basically gets some concerns about whether or not the woman is intoxicated, which is the standard prototype paradigm that you would expect in many of these traffic stops. So he asks her to get out. She gets out, and he gives her some field sobriety tests. Fine. And she doesn't do very well. Matter of fact, I think she passed 1 of 3. All right, so he says, well, fine, you're coming with me, lady, we're going down, and you're arrested for DUI. For some reason, the federal judge thought that not the stop was a problem, but that the police officer did not have a right to then go and give field sobriety tests. We argued it, and for some reason, she just didn't think that was correct, and that was extending the stop beyond the necessary reason for the initial stop anyway, since he thought it was unconstitutional. Guess what we did? 10th Circuit, interlocutory appeal, because she rejected qualified immunity, because she said there was a constitutional violation. We said, no, there wasn't. Guess what the 10th Circuit did? Bless them, in this case. They reversed the trial court. So we won. We got good law, got it resolved, dismissed, end of story. So it's a very useful thing from our standpoint to have an interlocutory appeal. 5, number 5. Okay, this one is interesting, and this is my humble opinion. But you have to remember, and I've tried a lot of cases with police officers in Utah, in federal court. With the exception of one very anomalous circumstance, they've all come out in favor. Because generally speaking, in Utah, people think highly of law enforcement. And there are a lot of reasons for that. First of all, I think our law enforcement are generally pretty well trained, pretty professional. They're not particularly aggressive. And I think most of the encounters, maybe some of you have had similar situations, I've certainly had them, but any encounters that you have are positive. They're not negative. And so I think the juries tend to bring that to the table when a police officer is being accused of some wrongdoing. The other thing is that generally we don't have some of the diversity, if you will, and I'm not aware, I don't live in certain parts of the country, so I don't know how it all works, but I'm sure there's some friction that comes out of that. We don't generally have that in Utah, generally, so the juries sort of reflect that when they think about police officers. I think they think police officers are helpful, they're their friend, and they try to do a good job. And I think they're willing to give them a benefit of the doubt, which is very, very helpful. So you always have to consider that that's generally where juries are when they're looking at a police officer. They don't look at a police officer and presume, oh, there's somebody there who's probably lying. They don't, that's not the way they are. So that's helpful from the standpoint of being aggressive. And that's why, remember, that there's sort of a backdrop to all this when it comes to defending cases. You always have to take the position, and the plaintiff's lawyers know this. You're taking a case that, let's say I'm defending, well, guess what? We're going to go to trial. You know, you're going to, in other words, I don't have a problem going to trial. I don't have a problem if that's what we have to do, because A, I can do it, B, I can do it, I think, reasonably well, and C, like, that's my nature. It's just, you know, I'm not into this giving out money kind of thing. It's just not my nature. That's not what we're going to do here. We're going to defend this thoroughly. And if at the end of the day there is some meritorious claim that you're asserting that really exists, then we'll talk about it. I have another governmental entity that I'm representing. Here's what happened. They all of a sudden had a claim against their police, and they paid it. They just had a claim, notice of claim, and they paid it. Guess what happened? About 9 months later, same lawyer, another claim. This time, he actually was forced to file a suit. They paid it. What do you think happened about a year later? Same lawyer. And his approach to this one was, oh, by the way, I'm about to file a lawsuit, so, like, can you make the settlement, like, you know, because he's thinking, hey, I hit the jackpot. Every time I file something against this, I get paid. Then they got us. And the whole point is, in the marching orders to us were, we've learned our lesson. We're just not going to pay this claim. We think we have a defensible case, and we want you to defend it, which we have, and successfully we got a toss out of federal courts on appeal in the 10th Circuit. But the whole point is they finally got it. You just can't pay. Because it provides an incentive for plaintiffs' lawyers to keep going back to the well, thinking, oh, they're going to pay. Okay, so that's something to remember if you go to trial. Next, number 4. Yeah, you're likely to win defensible cases. Here's a good example. Utah County, wonderful officer. And, well, anyway, I'll shortcut it because it's a little involved. But basically, 2 trials out of the same incident. We won them both because they're both defensible. But the first one, and here's the fact pattern. This poor officer's in the theater, off duty with his wife, and there's people in front of him, they're making noise during the presentation of the movie. So he kind of says, hey, do you mind, like, be quiet, da-da-da-da. And the fellow in front of him gets up and starts getting aggressive, da-da-da-da-da, wants to fight, and all of a sudden, next thing you know, he has to accost him and escort him out of the theater because he says, look, I'm a police officer, you don't understand, and we're not going to have a fight, but you're coming with me. And he's just trying to defuse the situation. Meanwhile, the girlfriend goes and jumps on my guy and starts making a big ruckus. She falls off. She claims she was made blind. Trust me, she wasn't. But in any event, you saw her. She had patches. She was on TV. It was amazing. But anyway, the point of the story was it was a totally, from our standpoint, bogus claim. So we tried the first time. Jury's out. It's like another week and a half trial in federal court. Jury's out, about 2 hours, no cause. Okay, fine. They appealed to the 10th Circuit. 10th Circuit, once again, does something really wonderful and says, well, one of the jury instructions is a little off. So they remand it. And so, okay, fine. So they go, well, we're going to try it again. Okay, we're going to try it again. So we try it again. Different judge, different jury. How long do you think they're out this time? 20 minutes. But anyway, but the whole point of the story is, if it's defensible, defend it. Because the likelihood is, not always, because juries are very unpredictable, and I'm the last person to suggest they're not. But anyway, you're probably going to win. If it's defensible, you're probably going to win. But it's worth doing, especially if you can do it well and you have good reason to do it. Next, 3. Okay, this is an interesting one. I had 2 of these cases. I kind of got a lot of grief in my office about these cases. But here was the deal. There was a way of testing people for blood alcohol. And they were using catheters, and people wouldn't cooperate. And so there was a case that we had where a woman, it's not quite as bad as it sounds, but she was taken down to the sheriff's office, and they forced her, you know, there was a nurse, and it was totally appropriate that way. But anyway, and she was catheterized, and that's how they got the specimen, and that's how they found out what her blood alcohol was. So she, of course, files a lawsuit. Oh my God, you wouldn't believe what they did to me. Now, trust me, there's a lot of facts that I'm not giving you, and if you could see what she's told the officers, it was pretty humorous because she had a mouth and it wouldn't quit. But anyway, but her claim was you involuntarily catheterized me forcibly in the office. There was a nurse, but you know, it wasn't a good situation, and that's a violation of my Fourth Amendment, constitutional violation. And you know what? At first blush, when you tell people that, you know, people go, right? Well, I didn't defend this case. So anyway, so we figure out something, and we come up with a fairly good argument on a motion for summary judgment, and Judge Benson says, "You're right. Sorry. Boom, out of here." Dismisses the case. Okay. Then there's another one. And it's out of a different county. This time it's a guy. And apparently he was offered whatever and was having some difficulty. So they catheterized him. Same argument, same situation. Guess what I was able to do? I was at least able to say, first of all, do you realize we already had a ruling out of the federal court on this precise issue, and there's nothing unconstitutional about it? You realize that? No. Okay, well maybe you should. And then secondly, when we get to the argument, guess what we argue? This was handled like a year ago by Judge Benson, and this is what he said, and here's his written opinion. It was a very scholarly opinion. He was right, by the way. Very scholarly opinion. Here it goes. So that was the end of that one. 2 forced catheterizations down the drain. But the point is, if you succeed, you can use those successes to build on others, to convince plaintiffs' lawyers that maybe they don't really have great cases, or maybe they better think about it, or maybe they're going to see this precedent. Like, for example, this Rickard case, we have a USIP case now out of Morgan County, and this is a classic plaintiff. He serves this huge command on the county. He doesn't think it's much, like $800,000. You know, it's a lot of money, but he doesn't think it's much. He's good because it's great. Hasn't filed a lawsuit, hasn't filed anything. And of course we go, wait a minute, what are you talking about? And basically it was his client was, well, she was very, very intoxicated, driving in a very, very bad way. Hum this, hum that. And it's a very serious case in a way because they end up shooting and she gets hit in the eye. And so it's not a good situation. But that said, the plaintiff's lawyer thinks, okay, they're going to settle. I've just given this demand, here are the facts, boom, I'll get some money. No. I get a call. And this plaintiff's lawyer, he says, hi, Peter, you know, you got my settlement, it's interesting. Well, you know, I've done all these cases and da-da-da-da, and I think it's reasonable and you guys ought to pay. Okay, fine. And then I go, well, what about the Rickard case? This was decided like 5 weeks ago. This is like I had a conversation in June, I think. Have you seen that case? Well, he said, yeah, but I don't think it's good. I said, well, no, I think it's dispositive. Not applicable. It's directly on point. The reason why our guys did what they did is because your client was trying to get away from them after, believe it or not, this is a true fact. 0.32. Now, anybody in this room, if you were 0.32, you'd be dead.